I'm Bill Treanor, the Dean of Georgetown Law, and we are so pleased to launch, as part of our 150th anniversary festivities, a new annual speaker series between the Georgetown University Law Center and the Indian Supreme Court. Comparative Constitutional Law Conversations is a collaboration between Georgetown Law and the Society for Democratic Rights in New Delhi. I want to thank the mastermind of this new series, our alumna, Vibhadatta Mahashi, class of 1992, and Associate Dean for Graduate and International Programs, Madhavi Sundar, for launching this together. This is an extraordinary opportunity to look at the role of the highest courts in the world's two largest democracies. The United States and India both have two of the world's strongest Supreme Courts. Unlike Britain, both India and the United States have written constitutions. While the Indian Supreme Court itself gives primacy to the judiciary, the primacy of the United States Supreme Court was crystallized in the case of Marbury versus Madison. We're launching this exciting new series with two conversations via Zoom this month, and plan to follow these with annual in-person lectures alternating each year between Washington, D.C. and New Delhi. Next week, we'll feature a conversation between Indian Supreme Court Justice Indu Malhotra and Georgetown Law Professor Lawrence Gostin on the right to health and the Constitution. Today, we are incredibly honored to host Indian Supreme Court Justice Uday Lalit alongside Georgetown's own Neal Katyal on the role of the judiciary in keeping the executive in check. Justice Lalit is the sixth senior advocate ever to be directly elevated to the Supreme Court. Prior to his elevation to the court, Justice Lalit practiced as senior counsel at the Supreme Court. Neal Katyal serves as the Paul and Patricia Saunders Professor of National Security Law and is the former acting Solicitor General of the United States. Professor Katyal has argued more cases in the United States Supreme Court than any other minority attorney. So thank you very much for joining us, Justice Lalit. Thank you very much for joining us, Professor Katyal. And I will be asking some of my own questions, and questions have been submitted in advance by our audience. If you would like to, I also would urge you to submit questions through the Q&A function on our Zoom so I can add them to the conversation. So let me begin with the role of courts in a democracy. A big picture question for both of you. Why are the Indian and US Supreme Courts considered to be such powerful highest courts compared to other countries? Let me begin with you, Justice Lalit, and then Professor Katyal. Why are the Indian and US Supreme Courts considered to be such powerful highest courts compared to other countries?
See, two issues. Number one, in terms of jurisdiction exercised by the Supreme Court, it's the Supreme Appellate Court in the country. According to the Indian Constitution, anything and everything can be appealed against in Supreme Court. So there are no restrictions. Even issues of fact in a given case can be gone into by the Supreme Court. So in terms of jurisdiction, it's one of the widest jurisdiction possible, which is vested in the apex court or the highest court of any country, number one. Number two, we have in the Indian Supreme Court, filing is every year something in the region of 40 to 50,000 cases every year. So sheer bulk of the matters, sheer volume of the matters, in terms of the kind of load that Supreme Court actually bears, perhaps it's also one of the largest loads which any apex court or any highest court of any country actually has to bear. Third, perhaps, issue is that every seventh person on this globe is an Indian. So therefore, in terms of jurisdiction which is exercisable so far as the highest number of people are concerned, that's also perhaps, I think, the highest. So therefore, these three facets actually make the Indian Supreme Court one of the strongest and one of the busiest courts in the entire world, perhaps.
Good. Thank you very much.
We work at least about 180 days a year. So therefore, actual hearing days are 180 days. Add to it the kind of work that every judge has to actually put in by way of judgment writing and everything, which perhaps is done at his residence. So therefore, this is the kind of work that we do. That's the Indian Supreme Court in short for your purpose.
Very good. Very good. Very powerful, but also very different from the United States Supreme Court.
That's right.
Professor Katyal?
So first of all, I just want to begin by welcoming Justice Lalit to this conversation.
Yes, thank you, Professor Katyal.
You're well known for your work in the United States, and it's a real pleasure to have you here. And more generally, I love the idea of these conversations because I feel like India, which is the world's largest democracy, doesn't get enough attention in America. And given the synergies between our two countries and our two legal systems, I think this kind of conversation is well overdue. And one of the greatest things about studying law at Georgetown is, of course, we're not just the epicenter of law for the United States in DC. We have such an international footprint of people coming through. And we'd, of course, love to welcome you here, Justice, once coronavirus ends, and to continue the conversation in person. But we're very grateful to have you doing this by Zoom.
Thank you, Professor Katyal. Thank you so much.
So with respect to your question, Bill, about why is the United States Supreme Court such a powerful institution, I think some of what Justice Lalit is saying applies to the United States. That is, our Supreme Court has wide jurisdiction, perhaps not as wide, because one of the big constraints on jurisdiction is it's limited generally to federal questions. And so if you have an issue of state law, and many of the burning issues in the United States are actually issues of state law, those aren't supposed to be appealed to the Supreme Court. So for example, I'm the prosecutor in the George Floyd murder case. We're going after the four police officers for their role in that killing. That's really an issue of state law. There might be some federal issues that apply, but that's actually, if it gets appealed, ultimately, it will be appealed largely to the state Supreme Court, the Minnesota Supreme Court. So that's, I think, a big difference or a limit on jurisdiction. The numbers at the United States Supreme Court are very different than India's as well. They are asked to hear about 10,000 cases a year. They hear about 60. So it's like, it's harder to get your case heard by the Supreme Court than it is to get in as a student for admission to Georgetown Law School, which is itself incredibly hard. But the point is, statistically, the court gets asked in the United States to take a lot of cases, but they take very, very few. And so as a result, they do not sit 180 days a year. They sit for 5 or 6 days a month for 8 months of the year, and only for about 3 hours on any given day. Now, they work incredibly hard, and there's a lot of work to be done. I think it's the hardest working branch of our system, but nonetheless, I think the numbers and volume are different. I think for the United States, to just finally answer Bill's question, I think the thing that makes it so different than other courts is that we do have what is known as the power of judicial review, the power to strike legislation down as unconstitutional. And that has been wielded by the Supreme Court in both very destructive ways and very powerful and good ways. So Dred Scott in 1857 struck down federal laws and ultimately gave rise to the Civil War. So that's obviously, on one end of the spectrum. On the other end of the spectrum, we have cases like Brown versus Board of Education, which desegregated our schools because of a Supreme Court order, not because of any popular legislative decision. And so that's the court acting at its best. And so, we have this dual-faced system in this country.
Very good. So I think that's a very powerful way to begin talking about the power of the courts and the similarity.
Can I just put in one sentence?
Yes, Your Honor.
What I gather is that 10,000 cases are perhaps filed every year, out of which 60 are actually heard in open court. Is that correct, Professor Katyal?
That is correct.
What happens in Indian Supreme Court is all the cases that are filed have to be heard in open court.
Yes, exactly. So we moved in 19.
There is a completely slight distinction in the way the Indian Supreme Court functions.
Exactly. So in 1875 and in 1925, we moved really to a much more discretionary system,
That's right.
which we call certiorari jurisdiction. So the Supreme Court doesn't have to hear every case. They get to decide. And it takes 4 of our 9 justices to agree to hear a case in order for the case to be heard. And of course, 5 out of the 9 to rule for a particular side.
So, and Your Honor, does the Indian Supreme Court hear 40,000 cases a year?
40,000 are filed, and normally all the cases are heard in about, say, 3 weeks' time. So therefore, on an average, we sit in benches. We are about, say, 34 judges in Supreme Court. So we sit in benches of 2 or 3 judges. So therefore, effectively on a particular day, working day, there could be about, say, 11 to 12 benches or even more than that. And about 60 odd cases are listed before each bench on Mondays and Fridays. So therefore, that's the turnover that we actually think in terms of.
That's remarkable.
Court functions.
So and I think that's a great kind of background on the 2 courts and their function. So now let's turn to the specific topic that we'll be delving into, the check on the executive. And we'll be talking about how the judiciary discharges its constitutional duty by continued course correction of the executive. So let me begin with Justice Lalit. How would you compare the extent of the power of the judiciary under the American and Indian constitutions to check the executive? And would you say that both constitutions create a stronger check on the executive than in other countries? And then I will turn to Professor Katyal.
Yes, qualitatively, the work actually at both the levels is almost identical. You start with that particular, that very famous sentence from Chief Justice Marshall in Madison, that Marbury versus Madison, is emphatically the province and duty of the judicial department to say what the law is. And that's exactly what the Supreme Court does. Now, in its functions, there are certain, path-breaking decisions and path-breaking ideas which have emerged. We are a very young democracy. We started in 1947. As compared to you, we are still in a very nascent stages. So over a period of last about, say, 70 odd years, the Indian Supreme Court has developed to such a levels that even the constitutional amendments to the Constitution can be challenged successfully in Supreme Court. So therefore, the ethos which has developed is that even the constitutional amendments are also subject to challenge and they can be invalidated by the Supreme Court. So therefore, that is the extent to which the judicial review has gone. Normally, we consider judicial review, the parameters are that you can actually check the actions on part of the executive. In certain cases, you can also go into the correctness of the law which has been enacted by legislatures. So not just the legislative actions or executive actions, even the constituent power by which you are amending the Constitution, that has also been seen, and in some of the cases, the constitutional amendments have also been invalidated by the Supreme Court. That's the extent of judicial review that we actually acknowledge, and we accept that the courts are vested with that power. So that's as strong as it can be.
In the United States, I would say we do have a power of judicial review. In practice, it isn't probably as powerful as one might think. That is, the system is set up to give a presumption of regularity to decisions made by the president and by Congress, particularly in national security matters. Just to deal with the amendment question that Justice Lalit recognized, the Supreme Court in Coleman versus Miller in the 1930s basically said they were going to stay out of constitutional amendments and generally not resolve those questions because they're political. And the reason for that is really constitutional amendments are the big check against a Supreme Court that is going too far in one direction. And so as a result of that, I think the court feels that they would be self-interested if they were ruling on the very check to their powers that would otherwise adhere. So in America, I would say, particularly in national security cases, very hard to challenge the president when he says national security. I've been on both sides of this, representing the federal government in national security cases and challenging it. And I would say those are among the rarest instances of judicial review being exercised to stop a government from doing something. Indeed, before the 2001 attacks, if you look back over American history, you would only find one example of the Supreme Court in a time of armed conflict saying no to a president when he said he needed something for national security. And that was the Steele seizure case in 1952, a very high point for our United States Supreme Court. But until otherwise, case after case, the courts would defer to the national security wishes of the political branches in America. Now, that changed a bit with Guantanamo. There were a couple of cases, that was my first Supreme Court case, in which the Supreme Court did say, no, Mr. President, you can't do this. A state of war is not a blank check for you to do whatever you want and create a legal black hole at Guantanamo. But for the most part, the system has operated to give the president and Congress wide berth in national security matters because our courts feel that they don't have the national security training, the intelligence training, and the like to make complicated decisions.
Should that be changed?
Well, I do think, and I don't mean to be political at all when I say this, but I do think President Trump has changed a bit the background assumptions on which this limited power of judicial review has been created. So I think that that one of the reasons the courts have stayed away from ruling in national security matters is because they feel there is a robust internal process before a decision gets made, that you have the National Security Council with literally participants on different, very different, coming at it from different perspectives. The State Department, which prizes diplomacy, the Defense Department, which maybe prizes a little more military, sitting in the same room debating the issue before a decision is made. Internal processes like the Office of Legal Counsel, Dean Treanor, where you once worked, providing legal opinions, sober legal opinions in advance, as opposed to justifying things after the fact in a rushed way and without the participation of the full federal government. So I think given this administration's process failures, the background assumption on which this very deferential judicial review the practice has been upended. And so, yes, I think the Supreme Court now should be doing a lot more than it has before.
Now, let me shift back to you, Justice Lalit. How, if at all, has the Indian Supreme Court been called upon to rule on the limits of national security powers?
We have when it comes to national security laws, there are two facets to it. Number one, our Constitution permits preventive detention in certain matters, where the executive is satisfied that in order to stop somebody from indulging in prejudicial activities, insofar as the interest of the state or interest of the nation or sovereignty of the nation is concerned, the person can be detained. And there are certain laws which have been actually framed by virtue of power which has been given by the Constitution. The Constitution then has actually developed certain checks and balances so far as that exercise of that power is concerned. So therefore, one area is essentially preventive detention, where without there being any adjudication so far as the guilt of the man is concerned, the man can still be detained for a period of, say, about 1 year or so. Then his detention is something which has to be in conformity with what the Constitution says and the parent laws under which the detention can be authorized. Naturally, whether that detention is in conformity with the Constitution and the laws is a matter of judicial review at times. So therefore, the matters actually keep coming before the courts. That's one facet of the matter. Then the second facet is that if there are guilty persons who are actually found to be guilty of certain offenses, which are where the statutes have been designed to take care of national security concerns. Now, these are special enactments where certain rules of evidence are actually relaxed. Now, the normal presumption that we go in criminal law is that unless and until, say, for instance, we have one principle in our criminal jurisprudence that a statement given to a police officer is inadmissible in evidence. Whatever be the stage, in whatever format the statement is given, the statement given to a police officer is inadmissible in evidence. It cannot be relied upon. Now, these rigors are actually relaxed in certain national security laws. So therefore, the procedural format gets relaxed so that the police are actually better equipped to deal with those matters. The prosecutions can also be on a firmer ground. So therefore, there are two sets of laws. Number one, like for instance, we had a law which has now been repealed, which is called Terrorist and Anti-Disruptive Activities Act. So therefore, terrorism was a matter of concern for some time in states like say Punjab, Haryana and other places. So therefore, in order to curb terrorism, this special law was actually enacted, which was in the realm of to take care of national security. So therefore, such laws were also sort of, the validity of such laws also came up for consideration before the Supreme Court. The Supreme Court upheld the validity, but laid down certain guidelines which need to be followed in case any prosecutions are supposed to be undertaken under those particular statutes and laws. So therefore, as I said, two areas, preventive detention and the laws which deal with punishment so far as the offenders are concerned. So therefore, these are broadly two areas in which our national security laws actually operate.
Actually, let me kind of ask one of the questions. We'll continue through the national security line, but I have a side question that one of our participants asked, which is, as you think about these questions, to what extent do you think about, or do you draw on foreign law? Or is it purely in India, the law of India, or in the United States, the law of the United States? Because that's, in the United States, that's certainly a large question. So Justice Lalit, how much is your thinking or the court's thinking influenced by laws of other countries?
See, our jurisprudence and everything, the systems are actually modeled on English laws. Before independence, we were ruled by a set of laws and set of principles which were typically given by the British. See, our procedural law is all actually made by British. We still follow that. Therefore, our basic principles are actually embedded in English jurisprudence. So therefore, we rely heavily on the English precedents, the English development. We also rely on American laws. For instance, the judgments of Chief Justice Marshall are quoted with reverence in many of the judgments of the Supreme Court. There are later judgments also which are actually quoted in one of the judgments. Why in one of the judgments? In many judgments. So therefore, we actually rely upon English as well as American precedents and authorities. So therefore, we are willing to actually learn from the experience of other countries.
And in the United States, I would say there's a pretty robust debate on this question. The late Justice Scalia taking one side of the debate, basically saying foreign law has nothing to teach America. Indeed, some people going so far, including our colleague at Georgetown, Nick Rosencrantz, saying that Congress should pass a law forbidding the Supreme Court from looking at any sources of foreign law. So that's one end of the extreme. On the other end, you have justices like Justice Breyer who say, of course it's relevant to understand how other countries are approaching a problem. And even if you're not going to strictly take one of their legal cases as precedent, you can use it to inform our pragmatic understanding of law in the Constitution.
And it's very.
One example, Dean Treanor, like for instance, our parliament and the state legislature, they have certain parliamentary privileges. Our constitution said that those privileges which were enjoyed by the House of Commons before the independence shall be enjoyed by the parliament. So then naturally the question arises, what were the privileges enjoyed by the House of Commons, the members of House of Commons? So naturally we have to rely on those English precedents and then sort of, look into those matters. I just gave you one example that how the debate then starts.
And it was very striking to me that in response to the first question, you began by referencing Marbury versus Madison.
Yes.
And as Professor Katyal says, in the United States, there's a very dramatic range of opinions as to whether reference to foreign laws and constitutions is relevant. But it was striking to me that that's the way you began one of your answers.
I may say that in one of the judgments, which is 7 judges of the Supreme Court, L. Chandra Kumar, Chief Justice Marshall has been quoted. In another judgment, Justice Frankfurter has been quoted. So therefore, there are a number of such occasions.
So let me, now let's go back to specifically national security.
Yes, please.
And let me, Justice Lalit, what would you call the high point of Indian Supreme Court jurisprudence with respect to protecting civil liberties against executive power?
The high point so far as the judge-made law? And yes. I would say that there are in fact about say 3 or 4 judgments on which one can actually rely on or can point them. The first one, of course, is the leading case in Keshwanand Bharati, which was a decision rendered by 13 judges. That time, the strength of the Supreme Court was 13, so it was full court which actually decided the matter. And one of the issues was whether the Parliament in its constituent power can amend the Constitution and what are the limitations on these amending power of the Constitution. So one issue which actually came up for consideration was, and by a majority of 7 to 6, what was decided was that of course the Parliament has the power to amend the Constitution, but it cannot amend or abrogate what is called the basic framework or the skeletal or the basic structure of the Constitution. Then the next question is, what exactly do you mean by basic structure of the Constitution? Say, for instance, adult suffrage, democracy, republican form of democracy, every person entitled to vote, parliamentary democracy, judicial review. So therefore, these were actually taken to be certain facets which are basic so far as the Constitution is concerned, and they cannot be amended. Now, one of the articles which was actually amended and inserted in the Constitution said that certain questions shall not be decided by the courts. So therefore, that's exactly the second clause of that particular section 3 of the amending act, 25th Amendment. That was actually struck down by the court to say that you cannot take away the power of judicial review. So therefore, judicial review being one of the basic features, so therefore the courts are still entitled to go into that question. And to the extent the amending power of the Constitution is trying to nullify or trying to stop the judiciary from going into that question, we declare that particular article itself to be invalid. Now that's the high point so far as the extent to which the judiciary had gone. That Keshwanand Bharati then became the pathbreaker, and many of the judgments have thereafter actually taken the same thought, same ethos further. So therefore, I would consider that when it comes to liberties of the citizen, that's where the high mark was actually Keshwanand Bharati.
That's very powerful. And as Professor Katyal said, not an analog we have in the United States. So let me ask you, Professor Katyal, what decision would you say is the high point of the American Supreme Court protecting civil liberties against executive power?
Well, there aren't very many. We're talking about a set of maybe two or three. The Youngstown steel seizure case in the 1950s is one, and the other was really the Guantanamo cases. For the most part, it's the Supreme Court letting decisions go in the national security context, as I was saying before, perhaps most notoriously the Hirabayashi and Korematsu cases in World War II, in which the Supreme Court upheld on national security grounds the forced internment of over 130,000 Japanese Americans. So if I had to pick one, and I'm obviously a little biased since I was involved in it, but I think the Guantanamo cases do really represent something pretty dramatic about our Constitution. This was just to take the one I did, Hamdan versus Rumsfeld, the president set up a military trial system on his own at Guantanamo, in which he handpicked all the judges, handpicked the defense counsel, handpicked the prosecutors, picked the defendants that would go before this tribunal, wrote all of the rules for the trial, defined the rights they had, which he later said zero constitutional rights, defined the punishments, which he said included the death penalty, and then went so far as to say the federal courts have no business reviewing what he's doing at Guantanamo Bay, no writ of habeas corpus. So the Supreme Court in Hamdan looked at that and said that went too far. And the case was brought, my client was Osama bin Laden's driver. So kind of the lowest of the low. And he brought his case against the highest official in the United States and the world, the president. And he won in the highest court of the land. That to me is the Supreme Court at its high watermark, saying, it doesn't matter who you are, you could be the nation's most powerful elected official, but if you transgress these limits on the Constitution, even if you say it's in the name of national security, we're going to stop you. To me, a very remarkable decision by our court.
It was a remarkable decision, and it was a remarkable case that you brought. So let me again draw back. Senior advocate at the Indian Supreme Court, Chandra Uday Singh asks, and this is a question for both of you, should the judiciary be more assertive with an assertive majoritarian government holding the reins? Should the judiciary be more assertive? So actually, let me start with you, Professor Katyal, and then I will ask Justice Lalit.
Well, I don't generally like the idea of a very assertive court system, because if you have a functioning set of processes in the Congress and in the executive branch, then those are people who have expertise, national security expertise in particular, intelligence expertise, but also accountability. If you think that they've gone too far, if, for example, you didn't like Guantanamo, you could vote them out of office. So that is I think the system at its best. If you're having that kind of robust dialogue we were talking about before, and internal checks and balances before decisions are made, then I think the judiciary doesn't have as much to do, for good reason, by constitutional design. By contrast, if you have, as we are now seeing, a system in which these processes are truncated and politicized, so that you're not actually getting the views of experts, but you're getting the views of folks who have certain knee-jerk reactions or who want to use these as political ploys as opposed to true national security devices, then the judiciary has to do more. That's what an economist would call a second best solution. First best, obviously, being let's hope the political branches do what they want, do what they need to do in terms of being checks and having these checks. But if that fails, then the judiciary has to be a backstop. And I think that is the original design in our Constitution. James Madison in Federalist 51 said the whole point of having these checks and balances and having Congress versus the courts versus the president is because people aren't angels. They're going to be ambitious. They're going to do things that are wrong. And so that's when the courts step in. But what I don't want to have happen is to have a regularized system in which the courts effectively are running our national security. And the best way to prevent that is to insist on good processes in the Congress and in the executive branch itself.
Okay, very good. Justice Lalit?
See, I would put it this way, that the fact that we get more than 40,000 cases a year shows the kind of faith and confidence that the general public have in the system. And they actually come to Supreme Court with the idea that yes, justice would be rendered to them. So I won't say that the judiciary has to be assertive or non-assertive. It has to deal with the cases which it has to deal. And whatever the case demands, it must do that. Whether the case demands invalidating any law, any statute, it must go whole hog. If the case doesn't demand, if the solace can be given without that, then whatever actually the case demands, the court should do that. So whether they have to be assertive or not depends upon the individual fact situation.
Very good. Thank you, Your Honor. Now let me move to a question that's very much on our minds in the United States right now, Supreme Court appointments. So the United States has lifetime appointments. India does not. Justice Lalit, how does that work in India? And do you think the United States should consider the Indian model?
See, according to the system that we follow, the judges of the Supreme Court retire after they attain 65 years of age. So therefore, the appointments are till they attain 65. As a result, what happens is that there is a quick turnover of judges. So therefore, whatever judges you have seen maybe 10 years back, the entire court has changed in the last 10 years. So therefore, the judges actually, there's a huge turnover. So therefore, new judges come in, new ideas come in. It's essentially good for having a vibrant court. So therefore, we are not bound by somebody's personal philosophies for a longer time. Of course, his contribution is something which is always respected. But in case it needs any kind of change or course correction, the subsequent, the judges or the benches will certainly sort of, take a different look in the matter. So therefore, according to me, the system that we follow is a good system, that it actually gives a retirement at the age of 65 so that fresh and younger talent always comes in, number one. Number two, the kind of pressure that we actually work under. Anything greater than 65 years, perhaps I think none of my colleagues would actually welcome the idea. To do about, say, 60 matters on a day-to-day basis for 180 days a year is not something that perhaps I think anybody would welcome beyond the age of 65. So therefore, this is something that we have adopted and we are quite satisfied with that.
Well, let me ask you, Professor Katyal, what do you think about mandatory retirement age? Require amendment?
Yeah, I wouldn't do it on the basis of age. I think that I don't like the signal that's sent by something like that, because I think, lots of people over the age of 65 are a lot wiser, smarter, and harder working than those of us who aren't. But I do like the idea of having term limits, and that is something I've been advocating for more than a decade. I think there's a bipartisan proposal right now to have 18-year terms for our Supreme Court justices, which is plenty long. It's an opportunity to get the benefit of their wisdom as they have been serving for a longer period of time, but it avoids the kind of macabre spectacle of people, worrying about, an elderly justice's health and when they're going to retire and so on, and the kind of unevenness in who appoints or who nominates these justices. So I think there's a lot to be said for it. And to inject, as Justice Lalit says, some fresh energy at regular intervals, as opposed to kind of sporadically dependent on the health of particular justices. But I think it will likely require a constitutional amendment to happen. But I would like to see that, because I think our current system isn't working tremendously well.
Very good. So another question that's linked, that's also very much on the minds of people in the United States, the number of justices. So again, I'll begin with you, Justice Lalit. Is there a fixed number in India? Has it changed over time? Should it?
It has changed. Our original constitution actually contemplated only 1 plus 7. So 7 judges. Over a period of time when Keshwananda Bharati was decided, their strength was 13 judges. Today, by successive amendments, the strength has been increased. And as of now, the strength is 34 judges. So depending upon the volume, the kind of filings that we are having every year, the kind of pressure on the court, so therefore the parliament has been actually making amendments and increasing the strength of the court. So today we function with 34 judges. As of now, there are 4 persons who have retired. So therefore, as of today, there are only 30 out of 34, but the strength is 34.
Do you ever all sit together, or is it just in panels?
No, that's what I said. We sit in benches. We sit in benches of minimum of 2 judges per bench, 2 or 3 on normal days. Whenever there are matters of importance, then the constitutional benches are actually formed, which could be anything above 5, 7, 9, 11 in odd numbers. So therefore, the largest bench that has actually sat in Supreme Court is that Keshwananda Bharati, 13 judges. Thereafter, it is only 11 judges. And then there are various benches of 9, 7, 5 strength. So therefore, there is nothing greater than 13.
Justice Lalit, may I ask you a question? What happens if the 13 judges don't represent a majority of the feelings of your full Indian Supreme Court on a particular matter, because they were selected and maybe only 6 or 7 of them have a certain view, but that is a minority view when viewed against the 30 or 34 justices?
No, it may happen. What you are saying is that perhaps I think supposing a view is taken by a bench of say 5 judges or 7 judges, that perhaps one can say theoretically that that could not be the view of the others as well. So therefore, that's only on a theoretical plane, that perhaps I think somebody else could have taken a different view. But then for that purposes, then we will have to have a court which actually sits together as a single body. And that is something which is physically impossible for this court, 34 of them to sit together and decide the matters. Then looking at the sheer bulk and the volume of the cases that we have, it will be impossible for us to cope up with that. If all 34 actually sit to decide only one case, what is going to happen so far as the rest of the cases are concerned? Therefore, we actually sit in benches, and that's what we have actually accepted. So for the court, the system, the jurisprudence has accepted, yes, that benches will be sitting in 2 or 3 or 5, 7 or so on and so forth.
It's so interesting that you say that. Our closest analogy is our 9th Circuit Court of Appeals, which governs our Western states, because they have 30 judges. And the way it works is if you argue a case, you argue it before a panel or a bench of 3 judges. And if you disagree and you lose, you can ask on a discretionary basis the court to hear it en banc in a panel of 11 judges. But there is a procedure called a super en banc, which says if you disagree with what the 11 judges do, you can ask all of the judges to hear the case. So theoretically, we have that power. But I think for the same practical reason you suggest, that it's very hard to get 30 judges together in a courtroom, it's never actually happened in real life. And one interesting question is whether Zoom will change that, because it's actually quite easy to get 30 judges on a Zoom call. And now the 9th Circuit has moved to, I just argued en banc last week in front of them in a gun control case, has moved to Zoom arguments. So there's an interesting thing in which is the technology now going to allow us to have these larger judicial hearings that we were never able to have before?
That's fascinating.
I must say at this point, just one addition. The original letters patent, which was actually granted to Bombay, Madras, and Calcutta High Courts, that was in the year 1872. That was under the signature of the Crown. When the courts were constituted, the original jurisdiction would be with a single judge in the High Court, and an appeal from that particular decision of the single judge could lie before a division bench of 2 judges. So an intra-court appeal, something like what you say in the Ninth Circuit, so that was regularly provided in the letters patent, and we still follow that practice in many high courts, that the judgments of single judges of the high court are appealable before a division bench of 2 judges.
Actually, Your Honor, when you have, say, 13 justices on a case, how are they chosen by lottery, or how are they selected?
That's what we say. That's the prerogative of the Chief Justice to say that who shall be sitting and who shall be hearing what cases. So the Chief Justice then decides as to what shall be the benches, the formation of the benches. We call it roster. So therefore, he decides what roster shall be actually seen by particular benches, or a set of matters shall be listed before a bench of 5 judges or 7 judges, and the composition of those benches shall be A, B, C, D, or whatever he decides. So it goes by the pure discretion of the Chief Justice of the court.
And does the Chief Justice announce his how he decides who will be on the roster in advance? In other words,
he announces in advance. Yes, the judges are also sounded that you shall be sitting on so and so bench, etc. But that's the pure discretion of the Chief Justice.
I meant not the names, but the process. So in other words, does he say, I'm going to pick the judges randomly, or I'm going to pick the judges based on my views as who'll be good? Or, I mean, what?
No, there is nothing such as any reasons why he has formed a particular bench. We go by the discretion exercised by the Chief. Nobody questions.
Wow. In America, the Chief Justice is called the first among equals, but he is much more on parity with the other 8 than he does. He has certainly no special powers to constitute a roster in any given way. So that's a real fundamental difference between our systems, because
yes,
for us,
that's there. That's the difference is definitely there. Yeah. When it comes to deciding a case, the Chief Justice is as good as any other judge. The Chief Justice can be in minority, the other judges can actually overrule him. But when it comes to formation of benches, he definitely has that power.
That's fascinating. So actually, let me go back to you now, Professor Katyal. Court packing. What are your thoughts on that?
So our Constitution doesn't specify the number of justices to serve on the Supreme Court. And, we started with 5, then we had 6. At one point, we had 10. But since 1867 or 1868, we've had 9 justices on the court. And in general, that has worked very well. I think the problem occurs when you have one political party that has played some ducks and drakes with the federal judiciary and has taken steps to block people from being considered for nomination to the court or even have a hearing, and then to have others rushed through. And I think that's going to create a lopsided court. And so, I think just descriptively, just leaving apart normatively, because I think that court packing in general is not a good idea, because if, let's say, the Democrats go to 13 or 15, the Republicans could win in 2028 and go to 19 or 21. And then in 2032, the Democrats could win. And, ultimately we'll have the 30 or 34 judges of India as our United States Supreme Court. There's no logical stopping point to where this ends. And while it makes sense for India, I think, to have 30 or 34 justices because it is such a large country, there are other Supreme Courts around the world like Switzerland. They have 30 members too, and that's a tiny country. And so, I think I think that it's not in general a good idea, but it is an entirely understandable one, and perhaps the only appropriate reaction to the effectively court packing by the other side. And unfortunately, I think the Supreme Court is caught in the middle of this.
Okay, very good. And again, a question that really is one of the most powerful and significant questions that the United States is thinking through now about the court. So let me ask, and I have to say, we're almost out of time. So I have one final question that I want to ask. So we have really people from continents around the world participating, and our audience has many luminaries, including Dr. Harsh Mahajan, who was recently honored with a presidential award in India. And Dr. Mahajan asks, and let me direct this to you, Professor Katyal, is it true that in the United States, one can predict the way a judge of the United States will rule based on which president nominated that person?
Definitely not. Certainly sometimes it will matter. There are a series of cases which get a lot of popular attention in which the justice, the political party of the justice, that nominated the justice will matter. For example, 4 years ago, 2/3 of the decisions by our Supreme Court were unanimous. Last year, I think it was about 50%. That is 9-0 or 8-0 decisions. And I think that reflects the fact that there are still, while there are some areas in law that are very hotly contested and political, like abortion, affirmative action, religion, there are a whole set of other areas which are really important too, including search and seizure law or patents or things like that, in which there is more of a degree of consensus on the Supreme Court. Particularly as you see justices getting nominated because of the political positions they've taken before, that can be a predictor. So, when you have a Republican senator like Josh Hawley say, I will not vote to confirm anyone unless they're on the record as being against Roe versus Wade, that's going to limit who gets nominated to the Supreme Court. And very well may predict that justices vote if they're confirmed. So sometimes you can, sometimes you can't. But I'd encourage, one of the great things about our Supreme Court is it can be surprising. So if you just look in the last year, for example, Justices Gorsuch and Kavanaugh, who were the two appointees by President Trump, voted against him on his tax returns case, on whether he has to turn over his tax information. Justice Gorsuch wrote the opinion protecting same-sex employees in the workplace, which is not traditionally understood to be a conservative position. Justice Gorsuch also wrote a major opinion siding with Native American tribes, one of the most important victories for tribes in a generation. So, Chief Justice Roberts voting to strike down President Trump's DACA, his Dreamers, his immigration protection program. Lots of different decisions like that have happened as well. So I think, don't just read the newspaper headlines because the story is a lot more complicated.
Right. I think that's a very important point, both with respect to not being able to predict the way that they'll come out shortly after they're confirmed, but also in terms of the arc of their careers. Justice Stevens gave a talk called Learning on the Job, where he talked about how over the course of the arc of his career on the court, he reversed himself on many of the most significant issues of the day. So those are very important points.
And just to pick up on that, that's the one concern I have about the 18-year term proposals of the Supreme Court, which is I do think there is this wisdom which you see jurists get sometimes after 18 years, as Justice Stevens illustrates. And so if you do shorten the term, you do lose some of that.
Very good. Okay, one final question, then I'm going to turn over to Viva for a close. And the question is, we've really been talking largely about judicial review. So I'd like to close by talking about what we in the United States call the counter-majoritarian difficulty. So to both speakers, let me do Professor Katyal and then ending Justice Lalit. Is there a concern, or should there be, that unelected judges can strike down the will of the majority of the population? And how is that dynamic playing out now in both of our countries? So Professor Katyal and then Justice Lalit.
Yes, I think it's an absolutely important concern because the justices do have the power to take things off the table 100%. So, that's often for a good reason. So if a state wanted to have segregated schools right now, even if 100% of the people in that state wanted to do so, that's off the table. It's unconstitutional. That's a great thing, of course. But you could imagine another court that did something like strike down protection for guns, gun control near schools, which our Supreme Court struck down in 1995. and take that away from the American people, or the Violence Against Women Act struck down by this Supreme Court in 2000, something that protects women against domestic violence. So, there are downsides of this as well. And I think the most important thing you can do is nominate people to the Supreme Court who have a healthy appreciation for the finest traditions of the court, which are often to be judicial restraint, but every so often cases like Brown versus Board of Education or Obergefell to say, nope, that's not the way our constitutional Republican democracy operates.
Thank you. Katyal. Justice Lalit, same question.
I would share the same view. See, it is ultimately robust judiciary which will actually be the great answer to every problem. See, whether it is true that whatever the policies the executive or the legislature comes out with have the backing of the people in the sense that they are the representatives. And to a certain extent, one can say that the judges who have the power to invalidate those policies are not directly elected by people, but they are well trained in their sort of profile. They know what exactly is to be done. They are the best who are chosen by a process which has been well accepted. And if they show great judicial restraint, then that's the key answer and every problem would get solved.
Well, very good. I have to say, this has been an extraordinary conversation. Professor Katyal, to have your insights based on your work as a scholar and as an advocate, and Justice Lalit, you're a justice who I so profoundly admire. So this has been a remarkable conversation and a great way to launch this series. And I want to thank everybody who's participated. We also have many, many remarkable participants. So this is a launch, and we will have further conversations and dialogue between the United States and the Indian Supreme Court. And I want to turn matters over now for closing comments to Vibha Datta Makhija, who's a 1992 graduate of Georgetown Law in our international trade laws. And I just want to say, before I turn matters over, how profoundly grateful I am to Vibha. We're very focused at Georgetown Law on our ties to India and strengthening, and she has been a remarkable leader in that program and that initiative. And working with Dean Sunder in putting together this event today and our conversation on Monday, I am so grateful again. Professor Katyal, Justice Lalit, thank you. Vibha?
Thank you, Dean Treanor. Thank you.
So this was an extremely enthralling conversation. And as we had expected, while we were preparing for the conversation, I think we've had so many participants and probably there are a large number of questions, which we of course haven't had the time to calculate to both of them. So maybe we will repeat this at some other point of time. I also want to thank Justice Lalit for taking out time for us, because I can share this with you. Justice Lalit is a workaholic, and it's only because we have our autumn break in the Supreme Court that we've been able to catch him. Else, I'm sure we would have been deprived of his great views on the topic. Also, thank you, Mr. Katyal, for being with us. I'm very grateful for joining the Indian audience, because for a very long time, I was very, very keen on bringing you to the Indian audience. Thank you very much for joining us. Thank you, Dean
Thank you,
Treanor.
Vibha. Thank you so much. And thank you, Professor Katyal.
And I would also thank everybody on the team who made this come true. Thanks a lot. And of course, the audience for joining us today.
Very good.
Thank you. And I hope we'll see you all on Monday for our next series.
Very good. Well, thank you again, Professor Katyal, Justice Lalit, Vibha. Again, thank you for your vision. I want to recognize the whole team. We've had an extraordinary audience as well, and this was a remarkable conversation. So thank you all, and I will look forward, I hope, to seeing you all on Monday. Take care and goodbye.